The Law and You, a look at laws in St. Vincent and the Grenadines which affect our daily lives. The Law and You, presented by lawyer panel P.R Campbell QC and brought to you on SVG-TV as a public service.
Ladies and gentlemen, brothers and sisters, boys and girls, greetings. Welcome to another presentation of this public service nation-building series, The Law and You. This is program number 857, coming to you on Monday the 27th of March 2017. On this program, I will speak to you on the topic, the Election Petitions Part 2. But before getting into the topic, two very short preliminaries. Firstly, my condolences go out to all families which have suffered recent bereavements, and in particular, the Bacchus family, who lost a son, Mr. Alvin Bacchus, I understand at 3:30 this morning in a vehicular accident at Ratham Mill. And that family has had more than its fair share of tragedies. On a happier note, I would like to congratulate Senior Bishop Melford Pompey and the other members of the St. Mary's Spiritual Baptist Cathedral at Overland on a service I listened to yesterday afternoon on the radio to commemorate 30 years in the ministry for Senior Bishop Pompey and 58 years in existence for the St. Mary's Church. I unfortunately was not up to going to Overland, but I listened to the service on NBC Radio 705 and thoroughly enjoyed it. My congratulations to our Senior Bishop Pompey, vibrant Sister Esther, and all the members of St. Mary's. Well, I will keep it short for preliminaries because I have a lot of reading to do on the topic, the election petitions. Last program, you will recall my saying that we had not yet received either a written judgment from the Court of Appeal on the hearing of the election petitions in St. Lucia on the 7th of March, nor had we heard an announcement of who would be appointed to hear the petitions afresh. Well, on Friday, I got the information that an announcement had been made from St. Lucia, whereby the Chief Justice has appointed Her Ladyship, the Honorable Justice Escrow Henry, to hear the petitions in St. Vincent, and that they would be heard on the 2nd of May and the 4th of May. So at least we know where we stand where that is concerned. Apparently there was still no written decision from the Court of Appeal, but that is up to the parties involved. Now, someone sent me today on the internet by email a very learned, thorough, and authoritative discussion on the subject of election litigation in the Eastern Caribbean. It is in the form of a learned dissertation, a paper, written by former Justice of Appeal, the Honorable Don Mitchell, and published on the 9th of December 2014. So this is not something published in response to what has happened in St. Vincent and the Grenadines. This was published on the 9th of December 2014. And therefore we can take it as a statement of what the author perceived to have been the law on election litigation. Now, we know former Justice of Appeal Don Mitchell because he served right here in St. Vincent and the Grenadines during the time when I was Attorney General. And then after he was elevated to the Court of Appeal, he sat in the Court of Appeal for a number of years and is now apparently retired from the Court of Appeal. Justice Don Mitchell is a very learned man, and he had a specialty in constitutional law. And I just got this today, in fact, after midday today, and I had the chance to read it through. It's very long, very thorough. It runs to 81 paragraphs, and I wish that everybody could get the opportunity to read this. In particular, lawyers who are interested in election litigation should make this reading a must. And therefore, I am appealing to the person who sent this to me to send it to the president of the Bar Association for dissemination on the internet to all lawyers, and even to see if it cannot be published on the internet in St. Vincent and Grenadines. So thank you for the person who sent it. And I will do my best to read some of it now. It is so very long that there's no way I can get through this on 1, 2, or even 3, not even 4 programs. So what I'm going to do, I plan on this program tonight to read for you. I better not do it by paragraphs. Let me do it by the clock. So let me read for you up to about 10 minutes before the end of the program, and then let me ask the technician to give, when he gives me my 10-minute signal, I will then turn to the end of it and read the concluding paragraph. So at least you will get the beginning and the end. Now, a lot of it is legal analysis, which ordinary listeners will find a bit heavy to follow, and I don't want to say, you'll find it a bit boring. Let me not mince words. But for lawyers, this would be of extreme interest. I have told you before that election matters are very complicated, very complex. For example, the 2 petitions which are to be heard here on the 2nd and 4th of May, I understand from both sides that the petitions are going to be dealt with afresh, which means the petitions having been filed by the losing candidates in Central Leeward and North Windward, the government legal team, or let me say the legal team on behalf of the electoral office, will renew their attack on the petitions as filed. And apparently, the petitioners' lawyers will in turn attack the motion which seeks to attack the petition. This is all par for the course in election matters, because we're dealing with highly technical concepts. And as I mentioned to you before, twice before, there will be the right of appeal. So whoever loses before Justice Henry will almost certainly appeal to the Court of Appeal. Of course, as I told you before again, if an appeal is made to the Court of Appeal, which I think will be almost certain, but let me say if, because it hasn't happened yet, whatever ruling the Court of Appeal makes will be that. You cannot appeal further from the Court of Appeal of the Eastern Caribbean to the Privy Council in London, in all the constitutions of the Eastern Caribbean Supreme Court. Election matters, election petitions, you appeal once to our Court of Appeal, and what they say goes. You can't appeal further to London. So we all look forward to the hearings on the 2nd and the 4th of May. We look forward to the judgment, and then I am pretty sure we'll have to look forward to a further appeal, whoever loses, because there is so much at stake. So let me begin to read for you the article by Justice Don Mitchell, CBE QC. Now, to you non-lawyers listening to me, the language, of course, is legal language, and you will not be expected to understand everything, but bear with me. I have to read it as it is. I can't chop and change. So I will read the first few paragraphs and hopefully leave time to read the last few paragraphs, just to show you from Justice Mitchell's point of view just how complicated this subject is. Excuse me. The article is entitled Election-Related Litigation in the Eastern Caribbean Supreme Court by Don Mitchell, well, Justice Don Mitchell, it doesn't say Justice, it said Don Mitchell, CBE QC, former Justice of Appeal of the Eastern Caribbean Supreme Court system. I will call the paragraph numbers. 1. The process for presenting an election petition in the Eastern Caribbean Supreme Court is a highly technical and legally complex area of law, known well by only a few specialists. The rules for presentation and the service of the petition are neither transparent nor easily understandable. The requirements are onerous. Compliance requires considerable time, effort, and expense. The arcane language used may not be accurately understood by the layman. It seems that every effort has been made to block a petitioner's attempts to understand what he or she must do. All but the most determined and well-resourced petitioners are likely to be deterred by the procedure. With general elections due to be held in Antigua no later than April 2015, this topic is most appropriate to be raised at this time. Remember, I pause here to remind you that this article was written on the 9th of December 2014. So it spoke about elections which were planned for April 2015 in Anguilla. And because the author is from Anguilla, he has highlighted the provisions of the Anguilla Constitution and laws. So this paper relates specifically to Anguilla, but it is of general application insofar as it deals with the general principles. Okay. Paragraph 2. To understand the legal background to the procedure for contesting the result of an election in our region, we start with our constitutions. These provide that election petitions are heard by the High Court. So, for example, Section 41(2) of the Anguilla Constitution boldly states, quote, any question whether a person has been validly elected as a member of the Assembly shall be determined by the High Court, whose decision shall be final and not be subject to any appeal, unquote, except, of course, to the Court of Appeal. Paragraph 3. The right to present an election petition is further constrained by the statutory provisions. So, Section 64, 1A of the Anguilla Elections Act states that, quote, except as provided in paragraph B, the petition shall be presented within 21 days after the return made by the returning officer of the member to whose election the petition relates, unquote. Failure to file and serve the petition within the statutory period of 21 days is fatal. The period of 21 days is an improvement over the more traditional period of 7 days still provided by the legislation in some other countries. In St. Vincent, of course, it's 21 days as in Anguilla. Paragraph 4. There is usually no hint in our elections legislation as to what the grounds of an election petition might be. One possible ground is mentioned in Section 64, 1B of the Anguilla Act, which, however, merely states that, quote, if a person questions the return or election upon an allegation of corrupt practice and specifically alleges a payment of money or other reward to have been made by any member or to his account or with his privity since the time of the return in pursuance or in furtherance of such corrupt practices, the petition may be presented within 28 days after the date of the payment or other reward. This section only extends the period of time for filing and serving an election petition to 28 days where corrupt practices are alleged. This extension of time, no doubt, as in the UK, is in recognition of the inevitable difficulty faced by a petitioner in collecting evidence of corrupt practice. Paragraph 5. Where the elections legislation sets out the basis for declaring an election void by listing the offenses on conviction whereof a candidate occurs the penalty of disqualification for membership of the House and the avoidance of his election, then it is important to be certain that the offense alleged in the petition to have been committed by the candidate is one of the listed offenses, and that he has been prosecuted and convicted of the offense. Paragraph 6. Our constitutions, election statutes, and the appropriate case law require an election petition to be presented within a specified time frame in a particular manner and to provide specific information. At the conclusion of the trial, the judge must determine whether the person elected was in fact duly elected or whether the election is void. The court has power to declare some other person elected. Okay. I will now turn to the concluding article, the concluding paragraphs, as I promised, having got my 10-minute signal. So I'm going to be reading to you, and I want to make sure I don't. All right. I'm going to be reading to you from paragraph 70. There is a good argument also that the question whether a candidate is disqualified should be dealt with administratively before the election rather than by means of a petition following the election. Apparent disqualification is at present not usually a ground for invalidating a candidate's nomination. The result is that a candidate may be elected even though he or she may be disqualified, leaving it for an expensive and uncertain challenge to be made through the courts. In Anguilla, there is a proposal that the question be settled by authorizing the returning officer on nomination day to call on the candidate to swear an oath as to his qualification. I leave out the rest of paragraph 70 and go on to 71. It is true for all our jurisdictions, so far as I am aware, that under the present rules, the grounds of a petition may not be amended once submitted. Once the statutory limit for filing a petition has passed, further grounds may not be admitted to an existing petition, nor any new issues that arise be investigated, even if they cast doubt on the validity of the result. It is of concern that no matter how meritorious, the time for filing or amending a petition cannot be varied, even with the leave of the court. There is a good argument to be made on the grounds of a petition should be able to be altered as new information that casts doubts on the validity of an election comes to light. Paragraph 72. Different decisions reached by different courts as to what exactly are the requirements of the law introduce uncertainty as to whether a petition will be struck out. Particular difficulty is encountered in satisfying the court that sufficient particulars of fraud on the part of the successful candidate or his agents have been pleaded. The previous practice of requiring a respondent to apply to the court for an order for further particulars of the alleged fraud, if he requires them, has ceased to be followed. The civil procedure that fraud may not be pleaded generally, but must be particularized, has instead prevailed. Now, I'm going to have to fast forward, and I will omit paragraphs 73, 74, 75, 76, and I probably should go on to the conclusion. I'll omit 77 as well. Paragraph 78, and do forgive me for chopping it up, but I want to get on to the conclusion because without the conclusion you'd be left really hanging, and I want you to understand that we are dealing with a complex area of law. And anyone who seeks to tell you otherwise is not telling you the truth. Paragraph 78. Our 9 jurisdictions of the Eastern Caribbean Supreme Court fall into several distinct categories when considering election petitions. The situation is fluid, and which category any one of us is located in changes from time to time. First, the most traditional type is the country that has no election petition rules in its election law, so that the UK rules apply. The second type is a country that has included in its law a number of rules governing the presentation and hearing of an election petition, as Anguilla has. The third type is the country like St. Kitts Nevis, that has persuaded the Chief Justice to make an extensive set of election petition rules so that the UK rules no longer apply. Paragraph 79. A political candidate must consider what legal process he or she should commence, depending on which of the 3 categories his country falls in, to ensure a fair election. He may decide to bring a challenge to the registration process by filing an appeal to the High Court. Alternatively, he may be advised to file a claim or to seek judicial review or to file a constitutional motion, either before, during, or after the election, depending on the wrong done and the relief sought. or he may be advised to await the outcome of the election and to file a petition to challenge his opponent's election. Paragraph 80. In each of our 9 jurisdictions, the filing of an election petition after the election has concluded is the standard procedure for challenging the election of a candidate who it is alleged was wrongfully elected. The jurisdiction to regulate membership in Parliament is, in the constitutional theory of the separation of powers, vested in Parliament itself. The court has no place in determining the validity of an election of a member of the House, except to the extent that Parliament has delegated that power to the court. The rules governing the presentment of an election petition and its trial are onerous and restrictive. The public policy behind this stance is the need to ensure that there is no delay in determining who the persons are who are entitled to form the government immediately after elections have ended. This public policy has been determined by the courts of the UK and the West Indies to supersede the need to ensure that the election has been fairly conducted. A challenge to an unfair election is permitted, but it must be prosecuted within strict guidelines and timetables. Final paragraph. The interlocutory application to strike out an election petition is one of the strongest and most efficient mechanisms available to a successful candidate whose election is being challenged by a petition. Even with the new election rules being rolled out, candidates and their lawyers will, in the years to come, continue to be ingenious and imaginative in attempting to persuade the court to strike out an election petition challenge filed against their election. The courts, on their part, will continue to struggle to strike a balance between the imperatives of, on the one hand, ensuring that elections are conducted within the rules set by the Constitution and the election statutes, and on the other, of ensuring that candidates declared defeated at the polls do not unnecessarily hold up the formation of a new government immediately after an election has concluded. Don Mitchell, 12th. I was mistaken when I said 9th of December. It was really it's written 9/12/14, and I interpreted at the front to read 9 December 2014, but it's written at the back 12 September 2014. So that is the true date of the article. I was reading to you extracts from a learned legal article by former Justice of Appeal of the Eastern Caribbean Supreme Court, Justice Don Mitchell QC, in which he was making the point that the election petition machinery is complicated, complex, and has rigid time frames. So I will hopefully withhold further comment until after the election petitions have been presented on the 2nd and 4th of May, and we have received a result. Until then, let us follow the procedure, and we can be assured that the judges will do what they have to do. So that is all from this program of The Law and You, program 857. I look forward to being of further service to you next week, Monday TV, for another presentation in this public service nation building series, The Law and You. Do have a pleasant and enjoyable week, ladies and gentlemen, brothers and sisters, boys and girls, and may the good Lord continue to bless us all.
The Law and You, a look at laws in St. Vincent and the Grenadines which affect our daily lives. The Law and You, presented by lawyer panel P.R Campbell QC and brought to you on SVG-TV as a public service.